So I am the head of legal and the data protection officer at Mailjet, and I've taken my company on a GDPR compliance roadmap. This process for us began about 1 year ago. So it was in February of 2017 where we went ahead and identified the importance of GDPR. So at Mailjet, we have our customers' personal data, and being an email solution in a form of SaaS, we do have an uploading of our clients' contact list. So that could include names, addresses, email addresses, IP addresses, information about the job titles, maybe phone numbers, birthdays. All of this is personal information, and because we send billions of emails a month, we do process this personal data in a large scale. So for us, GDPR is something very important and that we must be in compliance. And we decided to go through this GDPR compliance roadmap starting last year. So being the head of legal at the time, I did a project management analysis of the whole article, of the entire regulation, starting from Article 1 to Article 99, and put in together all of the obligations. So starting just generally in February and March to do an internal analysis and come up with our strategy, and then go ahead and reason every single obligation that we had to put into place and all the steps that we needed to take from that point. So I came up with a compliance roadmap. I'm sharing just quickly some of the highlights of that roadmap over the last year. Which included nominating a DPO, which was myself. Being the head of legal, it was a non-conflicting interest role in the company. And then formalizing training sessions with our internal employees and contractors. Then going forward and putting together the data breach plan and procedures, going for that data processing registry and record, auditing our third-party providers, making sure our TOMs were properly in place. TOMs, the technical and organizational measures that need to be put in place with high security in mind. So these are just some of the steps. So in these 3 steps, there were the 3 major and most challenging steps for us. So what I'm going to touch base today is basically implementing the Article 30 data processing registry, talking also about how to work with third parties and subcontractors, what questions need to be asked, and how to manage those relationships. Also touch base on exactly on an IT level, how to implement specific changes to the processes and what needs to be done. And then specifically speak to you about our own journey and a focus on Mailjet and the GDPR. So the first specific challenge and one of the obligations for us was to go forward with the Article 30 data processing registry. Now, under this Article 30 of the GDPR, companies need to go ahead and list out all the personal data. So this includes both external data of your company and internal data. So it gives you a global view of every piece of personal data that you hold, that you collect, that you process, and that you store. So this is really important in terms of understanding what data you do hold. So with this data processing and registry, there are some questions that you do need to ask yourself. So there's the personal data checklist that we have prepared, just for basically giving you an idea of what types of personal data you do hold, How exactly do you obtain this data? Where is this data stored? What's the specific purpose? What's your legal basis for collection? Who exactly uses it? Who controls it? All of these things need to be posed within your company. And in pursuing and dressing out this list of your personal data registry, you're in effect answering these questions. So it's a nice idea to put a listing and comply with all these specific informational standards. So I know in France, there is the CNIL, which is the French Data Protection Authority. They have a specific model online. So feel free to go and check out their model. The ICO in the UK also has a specific model available. And then at this point, it's really up to your own organization exactly how you want to pursue acquiring this list and figuring out exactly what personal data you do hold. So it's really important, even if Article 30 is not obligatory. So there are some exceptions to holding a registry of data. So for example, if you're a micro or small company, you have less than a certain number of employees or less than a certain amount of revenue per year, maybe you're not under this obligation, but nevertheless, it's a very good idea to have this data registry because it helps you to comply with the other obligations in their GDPR. And it also gives good business practices for you to have an overview, a global view of your entire data processing. So for example, at Mailjet, we went ahead and began this data processing record exercise in July. It took us about 2 months to complete. And once completed, it should always be updated. So it's not just a static document. It's really something that needs to be updated with every new feature or every new data processing that you entertain within your company. This needs to be updated and all the pertinent information needs to be included. Just to go back really quickly, another specific good practice is in formulating your personal data. It really helps you also identify your data retention policies. So let's say we went ahead and we put in all the information about the data we do store. Maybe your company realizes that there's certain data and personal data on your customers that's stored indefinitely. Here you can go ahead and make the internal decision that in terms of data processing, it's not absolutely necessary for us to keep this data for longer than necessary to provide services to our clients. So maybe you come up with a data retention policy internally to say that a period of 3 months after the processing is a good indicator for that deletion of the data. So there's this principle of data minimization that we find throughout the GDPR. This is really that you're not holding more data than is necessary for you to provide the specific finality and services to your client. So identify why you're collecting the data and then come up with some nice retention policies and some decisions internally in your company on how you're going to use that data and how long you're going to store it. So this whole process for us took us about 2 months and let us identify specifically the personal data that we do hold. And we came up with some data retention policies correspondingly. So another challenge for us was management of our suppliers and subcontractors. So under the GDPR, all actors who hold and process data have responsibility to secure that data and to ensure they have the right technical and organizational measures behind that processing of data. So, for example, Not only are the controllers today responsible, but also all sub-processors, suppliers, and sub-sub-suppliers. So think of that as a cycle. So from the first collection of the data, your data will go through a certain data flow or cycle in order to use or provide services to your client. You will be using third-party suppliers and subcontractors. So these third-party suppliers and contractors also need to have GDPR compliance in their journey. So why are we talking about third-party providers exactly under GDPR? So we all use different tools, and these tools and applications can collect extremely large amounts of data. So just for an example, there was an article published in The Guardian a few months back. It was an individual asking Tinder, you know, the dating application. He was asking them what type of personal data they held on him. Well, Tinder came back after some time, giving over 800 pages of all information that they held pertaining to the specific person. So it was also his likes on Facebook, it was his pictures and his uploads on Facebook. It was the tweets that he posted, just various information from all these other social networks, various information that they had on him from other sources. So it was really a shock to this individual saying that just this dating app had that much information, 800 pages, it's enormous. Um, so just keep in mind that all your tools that you're using could cost you specifically. So we all use them. Being a SaaS solution, we're using lead generation tools, chat tools, email service providers, um, hosting, data centers or clouds, marketing automation tools, your CRM tool for your sales and marketing teams, your client support. All of these tools also could cost you because, again, the responsibility to be compliant and to have the proper measures behind protecting all your clients' personal data is on all parties involved. So let me give you an example. Your email servicing provider is also at stake. And your email servicing provider can actually help you respond to your client's requests. It can also help you have that proper communication and obtain the proper opt-in consent requirements that are under our GDPR. So what we have here are specific obligations that you have on your part. But if you use a proper SaaS provider or proper third-party solution, that solution can also help you respond directly to your clients. As a controller, you have the right to specifically respond to the rights of your clients, the right to portability, the right to be forgotten, the right to information, the right to rectification. All of these need to be responded specifically within a time frame to your client. So can you respond? Can your third-party providers respond? That's really the questions that are interesting here and that should be asked. So how exactly do you go about verifying and working with your third-party providers? So we put together some steps, and the first one is really important. Take your time to collect an entire inventory and listing of all the solutions that you use. So we're talking here about the list specifically at Mailjet. When we thought when we first started this analysis on our third-party providers, I hadn't set a number. I had in my mind a number of maybe 20, 25 applications providers that we use. After really delving into the subject, interviewing everybody in various departments and listing out all the applications, that number was over 75. So it's important to understand who you use. So once you have that listing, then you go ahead and you map out that path that the data takes. So this is understanding what information and personal data you send to this third-party provider. So it's your CRM solution. Are they collecting personal information on your behalf? Are you sending to them specific information about the name of your contact? Are you using chat tools that are you're sending specific information about your customers? So you really need to understand what data they are collecting, what data they need to be using. And then as part of that, you review specifically your third-party providers' measures. So do they have specific technical and organizational measures in place to ensure the proper data processing standard that's required by GDPR? So this means, do they have the proper encryption of the data? Do they have a proper access and input control put in place? You can review these specific technical and organizational measures by going onto their website, checking their privacy policy, checking out the documentation that they have on their website. You can contact specifically your third-party providers. At Mailjet, what we did was we sent out specific third-party questionnaires where we asked them exactly the specific important questions on how they handle their data, what measures they have in place, where they store their data, how long they store it for. So all of this is really important to understand exactly what kind of measures are in place. And then once you've obtained those responses to your questions, then you can start assessing the level of risks behind that. So take a look at your third-party provider. Are they a critical provider? So is it something that you must absolutely use to provide the service to your client? Or maybe they're not so critical. Maybe they're just being used for ease. You can maybe internalize some of the elements that they use into your own organization. So you really need to assess the level of risks because, quite frankly, the more third-party providers that you use, the higher you are at risk that there will be a breach by one of those providers, that your customer personal data will be transmitted in incorrect fashion. So there's been several big fines. I can cite some made by the French Data Protection Authority and ICO. And those fines recently in January and February have targeted companies for the lack of verification of their third-party providers. So one of the examples is Darty in France, which is one of the major retailers, and they're really widespread throughout all of France. And after they sold services and sold products to their customers, they would have their customers fill out some form online. There was a third party that was providing the service, and that form collected all the data concerning the customer, their purchase order history, their information, phone numbers, addresses, email addresses, a lot of information. They had over 150,000 service customers on their website. And this third-party provider, you could easily just go on their website and find all the forms with all the customer personal data. So the CNIL, which is the French Data Protection Authority, put Darty on notice saying, hey, you guys look out for your third-party provider. All this information is public. It's a huge data breach. And they didn't check further about their measures. They were just saying, okay, they responded to us that it's under control, but they didn't actively check their third-party provider. And so Darty itself was fined for the lack of respect on data protection of their third-party provider. The fine in January was 100,000 euros, but the fine come May, I'm sure will be 4 to 5 times that amount. So it's really important to check your third-party providers and really take this seriously. So after assessing the level of risk, what next? Well, go ahead and review all the contracts that you have in place with them. Do you have contracts to begin with? Is it just signing up to their terms of service online? Do you have any other measures in place, contractual measures? This is where you can start proposing new contracts and clauses so that you can ensure they respect the data privacy. So you can introduce also limitations of liability, various responsibility co-sharing. There's a chance for some negotiation here, but let's enter into some standard, solid data protection agreements with all your third-party providers to ensure that they take privacy seriously and that they have the right measures in place. And then you can also include some kind of audit clauses, so you have the right to control and audit their measures if necessary. Then you will make sure they sign those clauses, provide proof of contact, and if they cannot respond to you, if they will not respond to you, or if they provide you really vague responses, well, now's your time to switch to a third-party provider that is GDPR compliant. This is really important to have in place, and so that you can assure yourself will not be at risk if there's a breach in the cycle of your data. So here it's where you can really decide, should I stay or should I go? Another challenge that we faced at Mailjet was putting in place all the IT processes. So here, you know, the GDPR has a lot of obligations, and these obligations are not just something that it's in terms of the legal department or your compliance department to take care of. It's also in terms of your IT department and the fact that your IT processes will be changed to include implementation of the new obligations. So just to give you some examples, here, your customers, your clients now have so much more control over their data. They have the right to ask you specific questions, like, I want to immediately have my consent withdrawn. I received your newsletter, I signed up for it, but today I no longer want to be receiving this newsletter. Or what exactly do you have information on me? So what kind of information do you have? You know, like how the specific user asked Tinder several months ago what information Tinder contained on that specific person. You can go and ask an organization, a company, exactly what personal data they have on you. It's the right to information, the right to access. There's also the right to portability. So your customer can ask you to have their data exported so that they can use it in a readable format to another third-party provider, or to use it personally for themselves, but they must have a way to have that personal data extracted. That's the right to portability. They have the right to have their data deleted, modified, rectified. So ask yourself internally the various questions that these customers can ask you, and are you ready to respond to them? Keep in mind that you have a really short period to respond. So within 30 days, I hope you can respond quickly. So let's go back into the data subject's rights, because this is really important, and you have to harmonize these rights and respond to the requests so that your IT processes and your IT team can also implement specifically these solutions. So for example, your contact or your customer wants to be erased completely from your system. They have the right to be forgotten. Right to be forgotten is not just simply, I will delete you from a list, or I will delete you from receiving our newsletter, or I will delete you. It's to be forgotten. That means that specific personal data will no longer be identifiable in your database. So, for example, there will be Julie@mailjet.com is requesting to be deleted and forgotten from your system. So you need to make sure that that specific email address is out completely. IT process could be, for example, at Mailjet, we've implemented a hashing system to anonymize that personal data. So it means the hashing, the email address julie@mailjet.com will now become xxx@mailjet.com. So if we do look for the specific address in our database, it is no longer identifiable as such. So that's a modification to make onto the IT level. At Mailjet before, there was no hashing. We would delete it per se from a specific contact list, but somehow in our logs or in our statistics or somehow in our database, we could refine or extract this personal data. You can today have a hashing process. There's other possibilities, and this really needs to be addressed specifically with your IT team. Also the portability request. The change specifically at Mailjet is the fact that today you can go onto the customer account and you can click an export button to export your contact lists. You can also click an export button to export all your statistics. So your event emailing statistics behind that. So there should be some tools and it helps to automate those tools because more and more you will be receiving requests from your customers. Maybe 6 months ago, we would receive 1 or 2 requests periodically. We really did not have a handful of requests. Today, we're seeing more and more. Data subjects are becoming more and more aware. And so they're just responding specifically and they want more information about what information they have. They want really clear consent opt-in. They want to be able to withdraw easily. So having an opt-in permission rules, opt-in consent, and also having proof of that consent. Under GDPR, you need to have documented evidence that there was an act specifically made that gives that specific concise consent. So documentation could be made. At Mailjet, we have a double opt-in confirmation email. So once, for example, you go to our website and you want to sign up for a newsletter, the information needs to be really clear about what newsletter you're signing up for and who and what information you're including. And then the right to be withdrawn needs to also be specifically acknowledged. And then once that person fills in the contact information to receive the newsletter, they receive a pop-up saying, thank you, look out for an email confirmation coming your way for you to go ahead and receive the newsletter. In that email confirmation, there's a link where they confirm, and that link technically can be used to store the consent. So there will be a log created behind that stores the date and time of the consent. And that could be your proof of consent if later you need to have that proof. So this is different storing systems. Again, this is something that your IT process needs to take into account and make sure that it's adjusted accordingly. Always remember that there is that principle of transparency that's included everywhere in the GDPR. So principle of transparency. All your communications with your clients, all your communications with your public need to be really clear and simple. You need to explain clearly why you are collecting the specific personal data, the reasons you're using them, your legal basis, and your legal purpose. So legal basis, just quickly recap, there are 6 legal bases for collection of personal data, for processing personal data. The most common is having a contract. So someone signs up or buys an article. They are under contract with you for you to provide that service. And then second basis could be consent. And consent has been really specified under GDPR. And with that, we have a legal basis for you to really prove your consent. There's the four others I'm not going to touch base on: legitimate interest, public interest. Those are other legal basis. So just remember, data subjects have really high increased control over their rights and their data. So let me talk to you about specifically Mailjet and how our journey, our compliance journey went into play. As I spoke a little bit before, this has been our compliance roadmap for at least 1 year now. We went ahead and implemented all the steps and the requirements. It took us over a year or up to a year. So if you're starting this process today, good luck. But there are solutions. We did not use any external tools, for example, in our compliance management. We didn't use any external tools for the data registry. These tools do exist, and maybe at this time, being a little shorter on the delays involved, using these tools could help you achieve compliance more quickly. So just to recap, what also helped us in obtaining GDPR compliance is the fact that we are ISO certified. Since October of last year, 2017, we obtained the ISO 27701 certification, and that goes to our standards of security. So everything in the GDPR based on data privacy by design and data privacy by default, we've had those processes in place because of our ISO process as well. So it helped us get on track and more aligned with the GDPR aspect. Not to be confused or overlapped, because there are some specific requirements of the GDPR that go above and beyond, because it is specifically related to the protection of personal data. There needs to be the data breach notification that's specific to personal data that's taken into account. So there are specific obligations that are above and beyond that everyone needs to be aware of. So if you have specific questions on the GDPR, at Mailjet, we've created a resources page that includes answers to key questions on GDPR, and it also includes our specific journey. So if you're interested in seeing Mailjet's journey, reading some of our articles and our blogs on the subject, all of this is available at our website. I suggest you do go and take a look. And I think at this point, we're going to open it up for your questions. I saw some questions popping in. I will answer them all in the question and answers. So I wanted just to continue to give you all the information on my presentation, and we will respond to all your questions. I'm not ignoring you guys. I see you. I just wanted to finish up with this and all the questions that you have posted. I see a bunch of them. Let's get through to that. Just quickly on Mailjet, I'll give you guys a plug. We are the all-in-one service email provider. So we have some really nice brands working with us. We send over 1.5 billion emails a month. We're considered the European leader in sending emails. We're really proud of our technology, our capabilities, both on the marketing and transactional side. We have our deliverability consulting, which kind of differentiate us from a lot of other ESPs out there. and we're always seeking to improve on our technology and keep in the standards with respecting data protection and including the highest level of security on our platform. So I think this time we'll open it up to the questions. I hope that my voice was not so nasal. Suffering a little bit here, guys. Thanks for your patience. So let's open it up to the questions.
Yeah, thank you, Darren. Question was about B2B, right? So for B2B companies, is our obligation to our clients. So to answer it, I'm echoing, so I'm just making myself mute again.
You're still there? Sorry, I think we lost you for a quick second.
Yeah, I'm still there. But I can hear myself. So it says, what if someone wants not to be in my database anymore? This question you can consume, right?
Okay, sorry, can you repeat them in the questions?
Okay, so it says, what if someone wants not to be in my database anymore, but at the same time not to ever be contacted again?
Okay, so I think the question here is regarding somebody's right to be forgotten. So there's really a difference between not wanting to be receiving any more newsletters or someone who takes it one step further and not wanting to be in your database whatsoever. So I think it's really clear to understand from the start your customer's requests. So if your customer is simply just asking not to receive the newsletter or not to receive a specific email communication from you, this can be done by an unsubscribe where the customer will be placed in a certain blacklist that they will not be receiving that specific communication. If the customer does specifically expressly tell you they want to be removed completely, then it's more asking to be forgotten. So they want to be completely deleted from your database. And that's when you really need to respect the customer request and go ahead and anonymize their data or proceed with some other technically feasible way to forget completely their personal information. That means that they are no longer identifiable in your database whatsoever. So if you are the controller and you are sending an email to that person and they request you to do that, you know that you can ask your email service provider to completely forget that person in the database, and this anonymization and hashing process should be respected. But it's also on your other providers. So for example, if you're sending data or personal data to other providers, for example, your CRM, make sure you're also completely deleting that person's personal data from your other third-party providers. So it's not just yourself as the controller, but make sure your third-party providers also will delete that completely.
Question is about second question is for B2B companies. Is our obligation to our clients or their customers? As in, are we responsible to field deletion requests from our customers, or do the requests have to come from our customers? I would advise you to look at the chat box because I can hear myself when it's echoing, so I'm pretty sure that people are getting bothered about it. Can you see the chat box?
Yes.
Okay. For B2B companies one.
Okay, so for the B2B question, the GDPR does not specifically differentiate between B2B and B2C. So any piece of data that's identifiable to a specific person is considered personal data, and you are under the obligation under GDPR. So here, for example, it's Julie at Mailjet.com. Well, Julie's sending you an email in a professional capacity. It's still identifiable who this person is, and that's still personal data. So if she then requests from you to delete that data, it needs to be respected. And let me just back up and explain the obligations of each person. So is it the obligation of your third-party provider? Is it you as a business? Is it who exactly is required to respond to Julie's request to be deleted? So here it's considered the controller who must respond to the right to be forgotten. The controller, for example, is your direct relationship with your client. Mailjet is a processor, so we are processing data on behalf of our controller. So at Mailjet, we are entering into contracts with our client, who then upload their contact list into our system. And in that contact list, there are personal email addresses. In that personal data, if our controller receives the request from that person, the controller, so our client needs to respond directly. So a lot of times our clients will ask us to do it, and us having that capability, we are also allowing the controller to respect their rights to their customers. I hope that clarifies the B2B question.
So I'm trying to explain here a bit. Somebody was my customer. I deleted their data, and then I don't know if they were my customer or not, and then I tried to approach them again. And I don't know if they were in my database, that I've forgotten them or not. So I'm trying to reach out. And so the question here is how to tackle this if you have already forgotten them and you don't even know if you should contact them again or not.
So if you've forgotten them, that means they are no longer in your database. You can't contact them. You don't have their information anymore. You really need to forget them. You can't just delete them from one contact list and then contact them again. If they really are asking you the right to be forgotten, then you no longer have that information in your database at all. There's no means for you, ways for you to contact them. If they come back to you, they will be considered like a brand new person. You have no more historic information on them.
Okay. Makes sense.
So it's the right to be forgotten. If they ask you on March 15th, then you will delete every single personal data on that person before March 15th. And then maybe like 3 years from now, they sign up for your newsletter. I think they have the right to change their mind and come back and request new information, or I don't know, buy another product from your website. That in that case, they're a brand new customer to you. And just a side note, there are other legal obligations that I'm sure you need to be aware of. For example, in France, you have an obligation to hold on to accounting invoices for a period of 6 years. So if there's a customer requesting that you forget them completely, you can do so with the caveat that their invoices are still in your accounting records for a period of time required by the law. And if there's like some specific law that you must keep their records for another reason, then go ahead and detail that inside your internal rules in your company. So on your data register, that's why it's a nice idea to have that data register where you know what personal data you have on people. And in that data register, you identify the fact that, for example, invoicing that I have needs to stay in our system for a period of 6 years, or whatever the specific local law requires you, and you implement that law. Same thing, for example, on employees. So you have maybe a legal requirement to keep their salary bulletin paychecks. So the paychecks, for example, you will include that in the data registry to say that the processing behind that is only for a certain period of time.
Makes sense. Makes sense. Can we get a GDPR compliant badge like this? One of the participants has asked.
Can I get the GDPR?
Compliant stamp like this that you have it in your slide right now.
The GDPR compliance stamp is not a certification. So this GDPR compliance stamp is the evaluation that we went through with a third-party company. So it's like an insurance and certification company who came in and audited us for a 2-day period and told us that we were in compliance with all the obligations of the GDPR and issued a report for us. So we are confident to say we are GDPR compliant. That third-party company is not accredited, which means the Data Protection Authority has not given any green lights or any accreditation to companies to give out the certification today. That's going to come after probably May or June.
Makes sense.
Today we have the stamp because we are proud of our 1-year accomplished efforts, but it's not a certification.
Okay, great. That's a good answer on that. Another interesting question: if you do prospecting to find new customers, is there what kind of legal basis is there? Is it legitimate interest, or how do you deal with that?
So it's really depending on your specific company. That's why it's important to do the data registry, to understand what data you do process. And then in that data registry, at every time there's a new processing of data, you need to identify the legal basis. And you need to identify the purpose. So, for example, collecting someone for sending them newsletters as mass marketing, I think it's really legal basis is consent, and you must always obtain the consent for that specific purpose. For commercial prospection, so if it's you met someone in face-to-face in a conference and you obtain their card and you send them a confirmation email to say, nice meeting you, here's the reason I'm contacting you, that could be an explicit consent basis. Legitimate interest could also be acknowledged for direct marketing purposes, commercial prospection purposes, but it's a decision that needs to be made by the company depending on what exactly, who they're contacting, why they're contacting, and what they're doing with that information.
Okay, makes sense. There is a question on chat box. I don't get it, but I'll just repeat it. Do we need some software to monitor every data in company notebooks? For example, employee who can download customer info need to have tracking software to prove that no data was stolen from his notebook. For example, move to a USB disk.
Okay, so I think as part of the third-party analysis that your company has to put in place, you need to really keep a hold of your user access and user access rights. which is an obligation under the GDPR to understand who in your company has the access and what they're doing with it. So, so keeping this really well documented is really necessary.
Okay, I have two interesting questions, and I will pose this now. Sharing it with you here. And there's a divide in the market, so I really want to know about these questions. What are the implications of GDPR for B2B sales practices, especially cold calling or cold emailing?
So again, in the GDPR regulation, they make no distinction whatsoever between B2B and B2C contact. So if you are going about sales practices, cold calling, there must be some kind of legitimate interest or legal basis for that cold calling or cold emailing. And I do suggest the GDPR makes it really important that every member state who adopts data privacy law into their own law has some derogations or some different interpretations. So, for example, you need to take a look at what the specific law will be to see whether legitimate interests will be allowed or not.
Are you okay?
Yeah, thanks.
Okay, no,
I'm struggling.
I'm about to end. So, if you are a service provider outside of the EU, what does the GDPR entail for you as a third party? What made it unique to say because they don't have privacy shield and they still want to show their customer they're compliant?
Okay, so according to Article 28, I believe, of the GDPR, all processors must have the appropriate technical and organizational measures in place with the same standards as the GDPR. So what does that translate in common language? Basically, that means you really need to have the same technical organizational measures in place, encryption of data, security standards, your proper input control, access control, all of this should be specified. And if you're working with a service provider outside of the EU, really good idea for you to put in place with them an EU model clause. So, for example, it's a contract between you and that service provider that ensures that their measures are up to par, that are in the same standards with the GDPR. So there are available the EU model clauses that are standard clauses that you can take from the EU Commission site, adapt these to your specific organization, and put them in place with these service providers outside the EU. There's no specificity within the GDPR that makes all data must stay in the EU. I think there's a myth behind that. Data can be transferred depending on your service providers or your agreements with your specific clients. They can go outside of the EU. That's not the problem. It needs to make sure that the security measures are in place to ensure the data protection behind them.
Perfect. So we are running out of time now, and I would like to thank Dareen for joining us. Thank you for being with us, even you were so ill. I hope people enjoyed the session. And again, thank you, and I hope people learn from this full presentation. And if you guys have any question, you can reach out to us, contact compliance.io, and we'll get back to you, or you can just write Dareen on Twitter. You'll find her very easy. Thank you, everyone.
Thank you so much, everyone. Thank you, Azar.
Bye. Yeah.
Bye.
Pleasure. Bye.
Thanks a lot. Hopefully this will go away a few days. Thank you, everybody.